So we have 2 minutes. I'm going to take this opportunity to pitch our future events. We have a bunch of events, and one of our presenters is actually here, Bob Oberstein. So I want to tell you guys what we've got going on for the rest of this semester. This is so welcome to, we have a few minutes left, everybody, but welcome to the inaugural virtual speaker series of the Tulane MJ program in labor and employment. I am so incredibly chuffed, as we say in the Commonwealth, to have everybody here. I'm so incredibly humbled and grateful for the folks that volunteered to present and to work with us on this endeavor. And we have a bunch of different really cool events coming up for us this semester. And these are all contained in the newsletter we sent you this afternoon. Our first newsletter happened today as well. Today, obviously, tonight, we're navigating the new pregnancy discrimination regime with Professor Laura Avery, JD of Kerry Murphy Law, Professor Gillian Egan, Corporate Counsel of APL, and myself. And then on February 13th, Claire Rouge, Vice President of Human Resources at Brown & Brown Absence Services Group, LLC. We're going to have a conversation about positive relationships between HR and management and how to make that happen with your CEO. On March 6th, Bob Oberstein, investigator, mediator, arbitrator, trainer, is going to be doing some training for us on Dobbs versus the workplace, the abortion conundrum. A very timely and challenging talk. I'm sure it is going to be awesome. On March 27th, this is an opportunity that came up for those of you interested in energy law or sustainability or environmental law. Professor Chris Svensson of the MJ and Energy Law will be talking about opportunities and challenges in U.S. offshore wind, if there's interest in that. And on April 3rd, Janelle Fernandez Balestro, Senior Human Resources Business Partner at Weintraub Tobin, will be talking about California pay transparency. So just to let you know, we are not, this isn't a closed kind of community. This isn't the kind of thing where, these are the totally awesome people and you're not awesome. If you have done a talk at your local SHRB, you've done something cool that you want to share with the group, you have done, you've created something and presented it to another regional or local organization that you want to share with our community, this is the space to do it. We are very much looking to make everybody an expert. And I think that is the goal, is to bring everybody's expertise to the fore and to create community and to serve everybody. So, check out the newsletter for a lot of other different things, but we also have the rest of the speaker series for the spring semester on it. All right, so thank you. It's 7:02, so we'll get started. I'm Professor Saru Matambanadzo. Tonight, I am privileged to be talking to you about the pregnancy discrimination regime with Professor Laura Avery of Kerry Murphy and Professor Gillian Egan of APL, Corporate Counsel APL.
To 12 or a certain time.
Shay, can you please turn off your microphone?
Without.
Thanks. Everybody turn off your microphone, please. Zoom bingo, right? Free space, and turn off your microphone. All right. Wonderful. So we will get started, and we will be recording their presentations, but the Q&A will not be recorded to preserve kind of spontaneity and community. All right, so in introducing them, just to let you know, we're going to kind of take this tripartite approach where Professor Avery will be talking a little bit about the history. I'll be talking about the new acts, and Professor Egan will be moving us forward and thinking about what's next in the realm of pregnancy discrimination. So without further ado, I'm going to turn the mic over to Professor Avery.
Good evening, everybody. I'm Professor Avery. For those who I haven't met, it is good to see some of my former students and current students here on Zoom tonight. So I'm going to talk about the history of law affecting and also the history of attitudes towards pregnant workers in America. I'll be referring to women a lot throughout the presentation, but with the caveat that biological women who identify as women are not the only people that can become pregnant, but nevertheless, well, the legislation and the statistics have primarily focused on women. So this is important stuff. 3/4 of women entering the workforce will become pregnant on the job. But prior to now, had no right as a federal matter anyway, even to modest accommodations that would protect them. The United States remains the only, or maybe one of the only, but maybe the only industrialized nation on earth with no federal policy mandating paid maternity leave as well. So where did this all begin? Well, it goes all the way back, basically. Women's biological capacity to become pregnant has long been the basis for the belief that women are unfit for employment in the public sphere. Going back into the 19th century, married through the 60s, married women were especially vulnerable to employment discrimination because of the societal expectation that a married woman fulfill her marital duty by bearing children. In the 1860s, it was commonly believed that marriage appropriately terminated wage work. In the 1880s, married women were expected to stay home if their husbands earned a sufficient income. In the 19th and early 20th century, the Victorian era doctors openly denounced the concept of a two-career marriage, meaning that the wife, of course, not the husband, belonged in the home. In fact, between 1890 and 1920, the acceptance of gainful employment of women was predicated to a great extent on the belief that they can and should retire to the home after marriage. Thereafter, from 1910 till about 1940, the societal understanding was that women would work lower end jobs without much room for advancement and then leave the workforce after marriage. Women did not leave employment upon marriage, they left upon pregnancy. Sometimes this was voluntary, sometimes it still is, of course, but others left because they knew they would be discharged once the pregnancy was revealed. Some employers also required women to leave upon learning of the pregnancy and would not rehire them for a year or two following birth, if at all. Some women were also fired, others relegated to lower ranking jobs, and the absence of maternity leave policies usually forced women to quit work without any other options. The common assumption was that pregnant women were disengaged from the workplace and so they belonged at home. Employers as late as the 60s had mandatory leave policies requiring women to leave work upon some month or benchmark in pregnancy, regardless of whether they were able and willing to continue working. These policies requiring mandatory leaves of absence during pregnancy were actually something of an outgrowth of Victorian views that it was actually obscene for a pregnant woman to be seen in public, particularly in the workplace. In fact, the reason why the history, if you look at the cases, the sort of landmark cases from the 70s that gave rise to the PDA, which we'll talk about in a moment, there was very little discussion in the jurisprudence and in scholarship regarding the history and the societal views about pregnancy, because pregnancy was not really okay to discuss at all. It's been, so the history of working during pregnancy has been pretty unexplored. People used to use very careful and discreet language regarding pregnancy, euphemisms such as in a family way and with child, even talking about not childbirth, but rather confinement. They influenced society's views, including those of pregnant women about themselves, this sort of like internalized misogyny that was derived from these views that pregnancy is embarrassing or would cause embarrassment to others in the workplace, and so forth. This was reflected in case law too, as well. I found a 1962 Ohio case where a waitress was forced to apply for a leave of absence when, after revealing her very early stage of pregnancy, her employer told her that she could not continue working because her appearance would be too offensive for the customers. At the same time, women in the 60s or as late as the 60s faced a double bind because pregnancy forced them out of jobs and at the same time made them ineligible for unemployment compensation benefits. In fact, the Ohio case I just referenced and many other pregnancy discrimination cases brought before the passage of Title VII in 1964 dealt with unemployment compensation. In addition to the social mores that I touched on, that it was inappropriate or offensive for pregnant women to be in public at all, there were common medical beliefs too that prevailed for many, many years regarding pregnancy and women working that were thought to justify the exclusion of women from the workplace. Women's work, and particularly maybe overwork, was blamed for a whole host of diseases and ailments, like not including but not limited to miscarriage, infant mortality, pelvic and uterine disease, and premature births. Let me add the caveat here that when I'm talking about women up until now, what I'm talking about is white middle-class women. White middle-class American women were forced out of the workplace, but this was not the case for Black and working-class women who were often forced to work during their pregnancies. In either case, the women lacked autonomy and were not able to make individualized decisions for themselves in all cases. Of course, into the early decades of the 20th century, many working class women were employed in factories and were not given any time off by their employers when they became pregnant or following birth of their child or for recovery, etc. So that is where we are coming from historically when we are approaching this legislation, which, if you think about the history of employment in America, is actually fairly new, even if you start with the very earliest ones. I forgot to share my really unimpressive PowerPoint presentation, so we'll catch up with it now. Briefly looking at statistics, which to me are less interesting than the history, but can still be informative. Of course, there are a lot of pregnancy discrimination charges. In the 15 years between 1997 and 2001, there were about 6,000 pregnancy discrimination charges filed with the EEOC and state employment agencies, which represents a massive increase over previous fiscal years in the 90s. Thereafter, the EEOC changed the way that they report statistics like this and excluded state agencies, so the numbers kind of level off, but that is not because they didn't necessarily increase. In 2015 to 2021, over 20,000 charges of pregnancy discrimination were filed just with the EEOC, including state agencies. That is not representative of the amount of what I will just call pregnancy discrimination, which includes not only ultimate employment decisions like termination on the basis of pregnancy or a pregnancy-related condition, but also requests for accommodations. The estimates are, of course, much higher than the amount of charges that actually get filed with the EEOC or state analogs. About 250,000 pregnant workers are denied requests for accommodations each year. It is estimated from research. And then there are many women who fear retaliation from their employers, and that will prevent them even from making a request for an accommodation entirely. There is evidence that pregnancy discrimination in general has a disproportionate impact on people of color. Black women filed 28.6% of pregnancy discrimination charges with the EEOC between 2011 and 2015, but make up only about 14.3% of the female workforce. So let's circle back to the 70s. Title VII, the landmark civil rights legislation, was passed in 1964, and thereafter a pair of really important cases followed in the 70s regarding pregnancy discrimination. I've only summarized the case General Electric versus Gilbert here. The other case, which is a 1976 case, the other one's a 1974 case where the Supreme Court held that pregnancy discrimination did not violate the Constitution. Gilbert held, in a nutshell, that discrimination on the basis of pregnancy was not sex discrimination. What was at issue in Gilbert was an employee benefits plan, which covered absences due to sickness and accidents and so forth. But absences related to pregnancy were not covered by the plan. A class of female employees brought a claim saying that this plan violated Title VII's prohibition against sex discrimination. And the Supreme Court held that it was not discriminatory since it did not divide women and men into separate categories for disparate treatment, but rather pregnant and non-pregnant people. In other words, discrimination on the basis of pregnancy is not sex discrimination. I note that the plan in Gilbert did ensure some male-only insurance risks like vasectomies. Then in 1977, there were still very small percentage, relatively small, of insurance plans that allowed sick leave for pregnancy-related illnesses. And so women's organizations, civil rights activists, and so forth started lobbying hard to end discrimination against pregnant workers, sought legislative relief from the Gilbert decision, and legislation was introduced to amend Title VII and overrule Gilbert, resulting in the Pregnancy Discrimination Act, which was passed in 1978. It amended Title VII to prohibit sex discrimination on the basis of pregnancy by modifying the terms because of sex or on the basis of sex to include because of or on the basis of pregnancy, childbirth, and related medical conditions. Of course, the PDA, the Pregnancy Discrimination Act, was necessary, but it wasn't sufficient. It has a number of shortcomings, some of which it has in common with Title VII itself. It focuses narrowly on discrimination. First of all, it does not require employers, generally speaking, to accommodate pregnant workers unless, in this is hard, but then unless the accommodations would be provided to similarly situated non-pregnant workers. But like I said, that's hard because the standards for comparing pregnant workers to those similarly situated are pretty unworkable. so employers basically couldn't do things like fire workers for being pregnant because of the PDA, but the law did not require them to make any workplace changes that were related to pregnancy. The PDA is, amended Title VII, which has its own limitations. It does not cover all employers, particularly always employers of fewer than 15 workers are not covered. And it's a discrimination statute as well, and setting aside the possibility of a hostile work environment based on pregnancy-related harassment. Aside from that situation, employees need to establish that there is an adverse employment action taken against them, as well as intent that the adverse employment action was motivated by a desire to discriminate. In this case, we're talking about on the basis of pregnancy, but the same is true of discrimination on the basis of sex, race, etc. under Title VII. It is, without getting into the reasons that you talk about in all of your employment discrimination courses, challenging, to say the least, to establish, which is ultimately the plaintiff's burden at trial, that the employer intended to discriminate against them on the basis of pregnancy when it made the adverse employment action. And frankly, it can be challenging to establish that an adverse employment action was even taken against you in the first place due to really some very strict and not textually supported judicial interpretations of the phrase adverse employment action. For example, I live in New Orleans. That's the Fifth Circuit, and the US Fifth Circuit has interpreted the term adverse employment action to mean ultimate employment decisions. So there are a number of things that can happen in employment that affect your terms and conditions of employment that fall short of that. There is other federal legislation that provides some protections to pregnant workers. The FMLA is a major one, but it's only unpaid leave for personal illness and family responsibilities, time off work for pregnancy-related issues, including prenatal care. You get up to 12 weeks of job-protected leave a year if your employer is big enough. Employers of fewer than 50 employees do not need to offer FMLA. I'm talking about as a federal matter. States can give greater protections, and some do. But FMLA, just like the PDA, does not require accommodations for pregnant women in the workplace. Interestingly, the FMLA was originally envisioned as a way to guarantee that pregnant women would not lose their jobs after they gave birth. So some legislative history there. Other federal legislation affecting pregnant people or people that formerly pregnant or may become pregnant include the ADA, which requires employers reasonably accommodate people with disabilities. Pregnancy is not held to be, well, not usually held to be a disability, definitely wasn't before the expansion of the definition of disability under the ADA. Some women have been held eligible for pregnancy-related conditions under the ADA, and courts have applied it to cover things like postpartum depression and recovery from a cesarean section. But it is limited as well. An employer, well, this is just an example of a limitation of the ADA, but an employer need not provide an accommodation that poses an undue hardship. And undue hardship is a fact specific and individualized inquiry. It won't be the same for all employees, and it won't be the same for all employers, which introduces a lot of uncertainty, not only for pregnant workers or workers who might become pregnant, but employers too. So we're here. The Pregnant Workers Fairness Act has passed after being introduced in every legislative session since 2012. Now, I note that makes it seem like I don't really know why. I don't know enough about the legislative history of this specific law to know why, but I do note that it was passed as part of like an omnibus spending bill. So reasons why it may have failed, and maybe one of the other professors intends to speak to this, I'm not sure, but some people will vote, you know, I don't know, they vote against things that don't have their, you know, that maybe are part of like an omnibus spending bill. It's not necessarily an objection to the Pregnant Workers Fairness Act. I looked for criticism of the Pregnant Workers Fairness Act quite a bit, and I couldn't find very much. This was bipartisan legislation finally passed prior to its passage in the years between 2012 and now. The federal inaction and women's groups and so forth motivated 23 states and Washington, D.C. to pass state legislation expanding protections for pregnant people in the workplace. Interestingly, at least interesting to me, one of those states is Louisiana, which is not a progressive legislature. But now the PWFA has finally passed. It differs from the ADA in important respects that I won't get into, but it largely incorporates the accommodation requirements of the ADA for work adjustments for pregnant workers. So with that, I will stop talking and pass it on to one of my colleagues.
Professor Avery is a hard act to follow. Her rigor is only exceeded by her charm and wonderfulness. So I appreciate her very much. So I'm going to talk to you. I don't have a PowerPoint for you. I usually do have a PowerPoint, but I'm going to talk to you about the two acts that were passed, and a little bit about them, and these two acts were passed kind of from my perspective, in a strange way for civil rights legislation. We've talked a little bit about the history of the Pregnancy Discrimination Act, which was passed in 1978 by Congress as a separate standalone act. It had massive amounts of bipartisan support. And I mean, interestingly, the Pregnancy Discrimination Act created really strange bedfellows. You had kind of like radical feminists and People at Now and the Catholic Church and a bunch of nuns all together. I mean, imagine all together supporting the same bill, because there was a perception at the time when the Supreme Court decided General Electric Company versus Gilbert, that decision, which basically said distinguishing between pregnant and non-pregnant persons as not a species of sex discrimination, that was just a crazy decision. Right, that the Supreme Court was just, we don't know what they were doing, right? That's pretty crazy. And you could get a bunch of nuns in the room with now that's what the testimony is fascinating. The Pregnancy Discrimination Act has a really robust legislative record of testimony. So it's an interesting scholarly as a scholar, I find it really interesting because there are those strange bedfellows. But I'm going to talk to you about two acts. And one is the Pregnant Workers Fairness Act, and the other is called the PUMP Act, PUMP Act. And I'm going to talk about Pregnant Workers Fairness first, and then the PUMP Act, which is, I love these acronyms, right? They're always so awkward and, kind of Providing Urgent Maternal Protections for Mothers. PUMP, right? Providing Urgent Maternal Protections for Mothers. These acts were passed as part of the as amendments to the omnibus fiscal year appropriations bill. And interestingly, just to let you know, these also had really robust bipartisan support. And so The Pregnant Worker Fairness Act was passed 73-24. Tons of Republicans, tons of Democrats in the Senate passed it as part of this bill. Now, when Senator Casey tried to get this passed in, because, you know, these two acts were passed by the House of Representatives, you know, in 2022 fairly easily, but they could not get them through the Senate as standalone bills. They were passed, though, in a really robust bipartisan way as part of this omnibus act. So the Pregnant Worker Fairness Act was passed 73-24. Tons of Republicans supported, including Louisiana Republican Senator Bill Cassidy, which is interesting. And, you know, there's a statement from him like, I am pro this bill. It is pro family. It is pro women. It is pro life. And I was like, wow, you know, it's a fascinating thing to have these two individuals together. The Pump Act was passed, wait for it, 92-5. Right, the amendment, and how they were passed is basically an amendment to the fiscal appropriations bill. And these acts had the support of the Chamber of Commerce and many others, including, you know, the National Breastfeeding Coalition, women's rights organizations, pediatricians. You know, there were 220 organizations that were in support of this. These two acts together. And what do they do? You know, the long story short is that they close loopholes into federal schemes that protect pregnant women and nursing women in the workplace. So I'm using women purposely. And the reason I'm using women purposely is because once again, right? And we talk about this in the sex and gender class, how not all people who are pregnant identify as women. Once again, providing urgent maternal protections for mothers and maternal. These acts are conceptualized in a gendered way by those who have passed them. Despite our best efforts, you know, in this program, despite the best efforts to, you know, ensure a kind of inclusive way of thinking about pregnancy, they're still kind of linked to motherhood. And so the Pregnant Worker Fairness Act, this will go into effect June 27th, 2023. It was first introduced in 2012 and reintroduced repeatedly 6 times before this. This is 7 times the charm, right? Perhaps the 7th time is the charm. So, you know, you might be asking yourself, why is it, Matambanadzo? Like, if I were asking just your opinion, and I can kind of give my opinion, like none of us are giving you legal advice. We're only giving you legal information. This is an educational opportunity, right? You know, this is not legal advice. We're only giving you legal information. You know, why is it that these acts didn't pass until the 7th time? Well, you know, to me, it's kind of the nature of our current political moment. Congress only does something when it's so overwhelmingly clear that they will enjoy massive national support for it from both sides of the aisle. So I think that, I'm not sure where the previous statistic was. I looked it up, and there are currently 30 states and the District of 30 states and the District of Columbia where, as part of their sex discrimination laws, pregnancy is protected and workers have a right to reasonable accommodations under the law. So it's not like Congress is leading. The majority of states, including conservative states like Louisiana, have determined that it is unreasonable for pregnant workers in the 8th and 9th month, or even in the 5th or 6th month, to be denied access to reasonable accommodations. So, you know, if you ask me why was the 7th time the charm, well, because everybody else has already gone ahead and paved the way. You know, other jurisdictions have led. And when the states lead in this way, Congress is just kind of catching up. But as an interesting footnote, neither of these acts could be passed as standalone bills, right? So even though there is a lot of support on both sides of the aisle from various constituencies for both of these bills. They couldn't get them passed as standalone. All right, which is kind of fascinating. So what does the Pregnant Worker Fairness Act do? Well, quite simply, right, it expands protections for pregnant workers in the workplace beyond the PDA. And what does it do? It requires that employers make reasonable accommodations through an interactive process to enable pregnant workers to continue working safely throughout their pregnancy, so long as the accommodations don't cause an undue hardship. Now, if this sounds familiar to you, it should. Why? Because it's modeled on the ADA, right? That this bill is explicitly modeled on the ADA. So, and we've got a little history of the PDA, and talked a little bit about the bipartisan support. But one of the things that the PDA did was expanded the definition of sex discrimination to be inclusive of discrimination on the basis of pregnancy, childbearing, and related medical conditions. Now, the problem with this is that it created what some commentators have talked about as a presumption of capacity or a presumption of productivism, right? Different commentators have talked about it different ways. And what does that mean? It assumed that pregnant workers, in order to receive this discrimination protection, would have to be productive and capable of working without any accommodation throughout their pregnancy. Now, if people have been pregnant, or they, even if you just know pregnant workers in the workplace, a lot of times pregnant workers need accommodation, right? The process of pregnancy as a biomedical and cultural condition often entails the necessity of adjustments throughout your life. Most of us, when we are pregnant, cannot wear stiletto heels. Right? Our feet change, different things happen. It might be difficult to be on our feet. The pregnancy presses on the bladder, causing the necessity for more restroom breaks, all sorts of things. Women were protected from discrimination so long as they were capable of working, right? And, the statute's a little bit, so long as they're protected, insofar as they are similarly situated in their capacity to work as non-pregnant people. It has this capacity presumption that is actually quite staggering. And even when pregnant employees looked around the workplace and saw that other workers would have similar accommodations, oftentimes those circumstances were distinguished. So let's think about a hypothetical, and this hypothetical mirrors a lot of cases. There's a lot of, Professor Egan, Professor Avery probably know this. There's a lot of these police officer cases in terms of pregnancy accommodation. It is a particularly fertile area for this discussion. Oh, God, I'm such a nerd. I wasn't even making that pun on purpose, right? So let's say you have a police officer, Joan, and, in the 8th month of her pregnancy, she needs desk duty, right? She can no longer run after suspects. She has to use the bathroom all the time. And when she's out in the field, in the car, it's hard to be in the city using the bathroom. Where do I find a bathroom? I can't go to Starbucks, right? I'm having to go to Starbucks every 30 minutes. My bladder is just being tested. And has a colleague, John, right? And John suffered a back injury on the job, and he has desk duty. Joan has no right to a similar accommodation. Why? Because John's injury emerges from a work-related circumstance, and Jones does not. So the worker doesn't have access. Joan doesn't have access necessarily to a reasonable accommodation. She can be put on unpaid leave. All sorts of things can happen to her. Now, one of the things that's interesting is oftentimes police officers are covered by public employee unions that sometimes have robust protections in their contracts for these things, but not all of these unions do. And there is, as I said, a robust series of cases where Joan is denied access to desk duty or light duty as a pregnant worker for accommodations, while her colleagues enjoy similar accommodations for workplace injuries. And this is kind of Young versus UPS was a similar kind of case in terms that the Supreme Court, Young versus UPS, and we talk about Young versus UPS in the contemporary sex discrimination class, and probably an intro to employment discrimination, we talk about it in both classes. Young versus UPS, everybody was holding their breath hoping that the Supreme Court would expand the PDA to require employers to provide reasonable accommodations to pregnant employees but they didn't do that. They didn't really do that much in that case. It was kind of this really disappointing case, but the fact pattern mirrors some of this. There was an individual who was a UPS driver, and she was seeking accommodations for lifting restrictions. She was pregnant on a similar basis to accommodations enjoyed by people who had issues with DOT certification or issues with workplace injuries, right? She wanted a similar accommodation. The company said, we're not going to give you a similar accommodation, right? You don't have a licensing restriction and you don't have a workplace injury. So we're not going to give you that accommodation because you, employee, are not similarly situated to the colleagues who have gotten this accommodation. And this is what some commentators have talked about as the tyranny of finding a comparator. Courts have required that women who are pregnant find a comparator who is a non-pregnant person who is being treated better than they are being treated. But, you know, employers are super, super good at distinguishing between the non-pregnant workers and the pregnant workers and saying, you, Joan, are not similarly situated to your colleague. So the part of the problem with the PDA is that, and this is the loophole, right? This is the capacity loophole, the productivity loophole. Pregnant workers, in order to receive the protections of the PDA, have and be treated on a similar basis, have to have the capacity to work. And finding a similarly situated person who's being treated better is kind of a difficult thing. So enter all of these state-based accommodations, statutes, 30 of them, and some surprising players, right? You know, Alaska, Kentucky, Louisiana, let's see, South Carolina, Texas, Tennessee, Utah, in addition, Wyoming, right? In addition to the typical players, right? Name what one of the ones you think is on there, probably they're on there, right? California, Colorado, Connecticut, etc. But there are some quite conservative states that have decided to provide more protections for pregnant workers. And of course, Washington, D.C. So what does the amendment to the Act do, to the Civil Rights Act, do as part of this larger omnibus legislation? Pregnant workers who work for employers that have more than 15 employees can receive reasonable accommodations unless that accommodation imposes a hardship or a burden. What else does it do, right? In ensuring these reasonable accommodations for pregnant workers, it enables them to safely perform their jobs. Employers, so what does the bill do? Like, if you look at the actual statutory text, how does it talk about these things, right? I told you kind of what it does. How does it talk about these things? Employers may not, i.e., it is an unlawful practice to refuse to make reasonable accommodations for limitations related to pregnancy, childbirth, or related medical conditions, unless this refusal is grounded in an undue hardship defense. Employers may not right? Require employees to accept any reasonable accommodation. Employers have to engage in that other interactive process similar to the ADA to come up with an accommodation. Employers cannot deny employment to an employee who is pregnant based upon a refusal to make accommodation. So what does that look like? When it comes to pregnancy, childbirth, and related medical conditions, the case law is rife with circumstances where pregnant employees are denied access to a reasonable accommodation like light duty or sitting on a stool or drinking more water or additional bathroom breaks or all sorts of other kinds of substantive reasonable accommodation that impose a minimal hardship on the employer, and they are put on leave. Walmart cashier, you cannot stand on your feet for 8 hours. No stool for you. You will stand. And if you can't stand, we're putting you on leave. The act prohibits that. Right? So they can't terminate an employee for asking for an accommodation. They can't put them on leave. And they cannot take other adverse action in terms of conditions of employee. They can't take adverse action, and this may look like reassigning somebody when they don't want to be reassigned, putting them somewhere undesirable, all sorts of things that could emerge from it. Now we have guidance that is supposed to be issued on these in February, so we're still waiting for the guidance, but I can tell you what the statute provides. It also prohibits, you can guess it, it's the R word, retaliation against pregnant employees who ask for these accommodations, right? So that's the guidance, right? That is the guidance, or we'll be waiting for the guidance. All right, the Pump Act, right, and the Maternal Act, it's gendered feminine, right? It's gendered for mothers. So you might be asking yourself, we always talk about in contemporary sex, the pregnant trans man. And, I think that the students in this course are savvy enough to understand that you are taking a great risk on if you're going to test the courts about the pregnant trans man, right? If you say, pregnant trans man, because the Pump Act is explicitly for mothers and you're not a mother, no protection for you for chest feeding afterward. That's a risky proposition from my perspective, right? I think that when you have an act like this, this is information. I'm conservative. This is the only time I'll say I'm conservative. Whoa, right? I'm conservative about these things when it comes to imposing risk and liability. I am conservative because chances are that a federal agency will expand it to include trans men, or, eventually. I like to get ahead of these things. Okay, the Pump Act, right? So the Pump Act is, and this is explicit in the statute, is a floor, not a ceiling for state and federal law. The Pump Act provides a minimum amount of protection for individuals who are breastfeeding or nursing, and it closes certain loopholes. The Pump Act is designed to amend and make more robust the Fair Labor Standards Act protections for breastfeeding and pumping milk. So, we go back in time and think about this for a minute. Under the Patient Protection Affordable Care Act, there were tons of goodies in that act. If you've ever read the act, and the tons of goodies. One of the things that the goodies involved a pro-breastfeeding policy, adopting a pro-breastfeeding policy. And what that led to was the ability, one of the things that was there was the ability for people to buy a breast pump on their FSA without being reimbursed. When I had my first child, in order to buy a breast pump, you had to seek reimbursement. But after the Patient Protection Affordable Care Act, right, the ACA, or as it's known in common parlance, Obamacare, right? Obamacare, which I actually love. Like if I were Obama, I'd be like, that's right. There's all sorts of treats in there, and Uncle Obama gave it to you, right? I would just lean in and embrace it, and I think that's what he's kind of done, what he and Biden have done. but it also entailed this protective legislation for pumping breast milk in the workplace. There were tons of problems with this legislation. One of the problems with the legislation was basic enforceability, right? The basic enforceability problem. The Fair Labor Standards Act was amended to protect individual workers for 1 year when they are breastfeeding. They were to be accorded reasonable breaks in a room that is not a bathroom, that is shielded from view by other employees. There's administrative guidance. What if on the Department of Labor, a door that closes, right? But part of the problem was that, and there was a case about this. It's interesting. The initial amendment to the Fair Labor Standards Act is for mothers. It is not for surrogates who don't have legal custody of their children, right? It is for mothers. And pumping the milk, it's for mothers who pump milk for their babies. It is not for the mother who's had a stillborn baby who is pumping milk to feed premature babies as a service, right, to the world. Congress has decided that those other mothers under the act, those other mothers, right? It is about mothers, right? I'm talking about mothers, not to be a jerk, but because it's explicit. That those other individuals should have access to the ability to pump milk and receive reasonable break time. What else does it do? It creates a cause of action, right? The initial amendment to the Fair Labor Standards Act was unenforceable because it created no cause of action. You weren't necessarily allowed to sue, and it created this terrible rigmarole where when employers refused to comply with the Fair Labor Standard protections for breastfeeding, they would go to the Department of Labor, and the Department of Labor would be like, yeah, we don't know what to do, right? And they would go to the courts and they would say, yeah, you don't have a cause of action. So it was a terrible situation where it wasn't clear how that would ever be enforced. Right now, good employers, I know everybody in this program complied, right? But naughty employers were like, you don't have a cause of action. I'm not doing anything, right? The Pump Act fixes that, right? Fixes that. The Pump Act, also makes break time available to individuals who are more available to individuals who are salaried employees. And in addition, expands protections for employees needing to express milk from 1 year to 2 years. So in line with recommendations by the WHO, that individuals should breastfeed and provide breast milk for children in the first 2 years of their life, we have expanded protections for pumping mothers from 1 year to 2 years. Right, so employers can no longer discharge an employee for expressing breast milk on the job, and they have these more expansive protections that eliminate some of the limitations, right? The Pump Act is different than the Pregnant Worker Fairness Act. It went into effect the day it was passed. So if your company is not in compliance with the Pump Act right now, it is in effect. But right, it went into effect the day it was passed, but enforcement will not be executed until April 28th, 2023. And guidance should be issued in late February. So, so I've given you kind of overviews of the act, and now I'm going to be quiet and I'm going to turn it over to Professor Egan. In saying, what was going on, why were these acts, not passed in a single-handed fashion, in a separate fashion? I think it's because, nobody in Congress wants to be seen as a bipartisan player, and voting for an amendment to an omnibus bill, that's the government running. It's preventing us from the fiscal cliff, and you can extract some little pork from it, etc. I think it's a more palatable political option for a lot of these congressmen. But this also shows you that Congress is not leading; it's following the states. All right, so I will be quiet and turn it over to Professor Egan.
You, thanks. So I'll just spend a little time kind of noodling around with you guys. I mean, I don't know, none of us know what's going to happen next, but I think it's really helpful and interesting to think about what is next in both, how these laws are going to land and what we might see coming out of the implementation of these laws and, any lawsuits that arise. And then also what the next steps in pregnancy protections might be. So this is all sort of a guess, but here we go. Let's guess. So the first thing I will say is it is not just pregnancy protection. It's kind of everything in the employment space is not being led by the federal government and hasn't for some time. And so then administrative agencies like the EEOC and the NLRB and others are just issuing guidance because they're like, what else are we going to do? And then states and even some municipalities, counties, cities in like California and Illinois and such are kind of experimenting and putting forth more protective, generally they're more employee protective, although we saw during coronavirus that some of the more conservative states decided to hop on the bandwagon and put out some laws protecting employees or employers in a more activist way that I hadn't normally seen. And all this to say, I work for a global company. We have people in 40 some states. This is awful. It is terrible to keep up with all this junk. And I think that businesses, U.S. Chamber of Commerce, I know my business team, we would rather see federal protections because it's so much easier to implement one thing than to keep track of, I probably have 60 or 70 jurisdictions that I have to kind of keep my eyeballs on because of all the cities that we're in that have protections too. So I personally will say that I and most of my in-house colleagues were very happy to see this law, in particular the PWFA, kind of piggyback on existing law. So all we have to do really is just kind of fold one extra category into a process that we already had in place. So that's very helpful. There are so many employment discrimination laws and employee protective laws, medical FMLA, and ADA and workers' comp and all of this that have slightly different standards. And so you have to sometimes you have to look at the same situation 30 times to catch each of the standards. So it's really helpful that this borrowed a lot of the language from the ADA. The PWFA did anyway. Some things as the PWFA is implemented and people start to bring cases, what I think we're obviously going to see is what is a known limitation. That's a term of art that is probably going to be argued. What's a limitation? Limitation is a word in the ADA. Does it substantially limit a major life activity? Is that going to be what they use here? Like, I don't know. And that has become so expansive since the Amendments Act of the ADA. And when was it? Well, I think it was 2008. So I wonder if we're going to borrow a lot of that same kind of expansiveness here, or if there will be a fight to keep it as narrow as possible. Also stemming from pregnancy, childbirth, and related conditions. I could see stemming from, and I could see related conditions. If you have pre-existing diabetes and then it gets worsened through pregnancy, is that stemming from the pregnancy or is that stemming from you had it already, fighting over that? I see it could possibly happen. Giving people leave, that part actually honestly worries me a little bit to think about figuring it out, that we cannot require an employee to take leave unless they want to, but we also are required to offer it under FMLA. There's workers' comp too, there's ADA leave, there's so many different kinds of leave is already so complicated. So now we have this other limiting factor on leave that's going to be, I think, a little bit confusing, and it's going to take us some time to figure out to feel safe in letting a person take a leave, and we'll probably end up papering it up a lot, that they actually wanted it. And I foresee some cases where people will say, well, I took a leave and I signed this paper saying I wanted to take a leave, but I felt pressured to do that. So I understand the impetus behind that. I think it's probably going to be a little bit messy to actually implement. What I, as a mother of 3, really did appreciate in this law, though, was that recognition that pregnancy is a temporary condition. It's going to end. It's going to end pretty quick. In the scope of my 20-something year career so far, I was pregnant for 9 months times 3 of it, and I'm never going to be pregnant again. Fingers crossed. And I always, like, just personally, I felt like it was very short-sighted. Some of the treatment that I received when I wanted to say, this is so limited. This is going to be, I have a lot of value to provide to you, and you're deciding not to take that value from me because I need a couple of months to recover from childbirth, So I do think that the PWFA's recognition that pregnancy is temporary and people can be accommodated. You can take away a couple of the essential functions of their job on a temporary basis because they'll be able to come back. I think it's going to be very protective, and actually is one of the most exciting things about this. But it also, I think, is going to be a place where we get into some fights, because what I foresee is some reluctance to make those accommodations, even though they're temporary, because then other people who are disabled, who will need them on a permanent basis, might point to that and say, oh, well, if you did it for her, I want to do it for me. And I think that employers might get a little reluctant and scared about setting a precedent. Too bad, they're going to have to consider it because that's what the law says. But I see that being a little area of tension too, like confusion and tension. Already determining what's an essential function of the job can be a little messy as it is, as a job description might not accurately reflect what they're doing. And it might be something that one person in the job would do 50% of the time, another person in the job would do only 10. So it's already sort of a messy issue. And I think adding this temporary accommodation of letting them not do an essential function for a while is going to be an area of some fights too. Let's see. The pregnant trans man thing, actually, Saru, that you brought up is something that I had thought about. And I wondered, I haven't thought about it sufficiently to write a legal brief on it here as I'm talking out loud, but I wondered if there's a way to sort of couple the PWFA with Title VII, which under Bostock would protect the pregnant trans man. If you could marry those two together to assure that these protections for mothers are also extended to fathers who get pregnant too. There aren't going to be many, I would anticipate, just because of the numbers, there aren't that many pregnant trans men. So I can't see this being a big area of concern or problems for employers to have to navigate, but I do see it being a big case one day. So we'll see. It'll be years before that will come out, but I think that is going to come up. And I do think there's a way to potentially couple those two laws together to sort of try to make a case. I, like you though, Saru, would be conservative in my application of this law and would definitely advise my business clients and advise any other clients I had to extend protections to a pregnant trans man. Why not, So that's kind of what I think for PWFA, where there's going to be we'll look to the guidance that comes out from the EEOC. It's also, a defense lawyer trick that you can't necessarily follow the EEOC guidance because then that becomes the law, basically. And so the EEOC gets the chance to write laws that don't go through notice and comment and all of that stuff. So, so my defense lawyer hat on, we'll look at it, but we'll also understand that sometimes the EEOC guidance is not reflective of something that is reasonable or can be done or should be done. But it's always helpful, right? And I think figuring out what's an undue hardship in these circumstances, figuring out if you can't do an essential function for the whole 9 months, or if you just can't do it for the last 2, or finding those dividing lines is going to be the challenge. Then just generally speaking in pregnancy protection, sort of bringing this all in, it has always been a very careful line to walk because you don't want to be paternalistic, like the Johnson Controls case, which was a Supreme Court case. I think it was in the 90s. where there was a rule that women of fertile age, whether pregnant or not, couldn't work with some chemicals, or I don't remember all the details, but this company had this rule. They had this chemical room that could harm fertility, and they wouldn't let women work in that chemical room, but men could, regardless of their age. Women of fertile age could not. And I think it was struck down because that was a paternalistic rule. Women get to decide if they want to risk, they need to have the information, and they get to decide if they want to potentially risk fertility by being in this room or not. Can't believe that room passes OSHA muster, but but that was a paternalistic rule, right? It was trying to be protective of women and their fertility and their ability to bear children in pregnancy. And women didn't want it because there's plenty of women in this world who don't ever have a baby and don't want to, and don't want to be held back by that kind of a paternalistic treatment. And you also have to be real careful. I mean, in our we have a harassment video, everybody has a video, you got to watch discrimination and harassment video. And one of the little vignettes in that video is a pregnant woman who is in a room, and they're all planning, he's going to go to this conference and present. And everyone's like, oh, well, you're not going to want to go. Obviously, travel is going to be hard for you. And she gets mad, and that is presented as a discriminatory, paternalistic, protective measure. You don't get to presume that she is not going to want to travel to that conference and do that. But you don't get to ask her when her due date is. You don't get to ask her any of that stuff. She has to decide if she's capable of it or not. And I think that's good and appropriate. But it's going to be a tricky line to walk between making women feel like they can take these protections and ask for them and not be penalized for doing so. And making sure they're offered, but also making sure that you're not singling out pregnant women and limiting too early or too fast or too much, limiting their ability to progress because you're worried about their health. So that's interesting. Let's see. So some of the pregnancy accommodations that we can all imagine are probably going to be asked for and have to be extended would be, going on light duty, just like I think someone who testified in the House maybe went a couple of years ago on this bill, said that she was an emergency medical technician, and she was given a lifting restriction for the last part of her pregnancy by her doctor. Everybody else who had hurt themselves at work or whatever could get light duty and desk duty. But she was not granted that because it was not a work-related injury, and she just was pregnant. She was not given that, and that put her in poverty. She lost her job, put her on SNAP benefits, and I don't know that I think in the testimony she hadn't ever been able to go back to being an EMT. She was, something that paid less. Huge to extend pre-existing light duty capacity to pregnant women as well. I think that's huge. Making schedule adjustments for doctor's appointments. Pregnant women have to go to the doctor, with increasing frequency as you get to the end. So making sure that women are able to take those and not get attendance points and that sort of thing. The stool, like Saru brought up, the ability to work remotely, the ability to take more frequent bathroom breaks, to hold a water bottle. These are some of the things that are going to probably be asked for and have to be given. And one thing that occurred to me is how some of these are hard to do because of a sort of scarcity mindset and it seems to be a smart business practice to reduce your headcount to the bare minimum that you need to get through, right? And some of these, like having people be gone for a doctor's appointment, or having people, switch from this job to this job for light duty for a while, or part of what makes it difficult to accommodate those things is because so many companies, I feel, run kind of on a thread. And I think that's a cultural thing in the United States. I'm sort of making this up, except that I know I did look before tonight at some of the protections that are provided in Germany and Denmark and Finland and other countries that have more. And, the only way I would think that they are able to provide 32 weeks, 50 weeks of leave to the mother and the father and the other kinds of accommodations they provide is if they've got enough people that they can absorb the extra work, or they have temps or someone come in. And I think that's if pregnancy protection, once this kind of percolates and gets through, and if protections continue to trend, toward being more protective, I just wonder if we're ever as a culture going to kind of reckon with that. The fact that if you have to run on a such a tight ship, you don't have any room to give people any breaks. And then I also wondered, and this is something I've wondered for a while, is about decoupling our health benefits from employment and what impact that would have on being able to provide accommodations like these, because you could have more staff, but every staff you add, you have the potential to add like the cost of family premiums for health benefits. And so that kind of drives a culture of trying to have as few employees as possible and work them as many hours as you legally can and safely can. And I've often wondered if that, I don't really foresee, I think part of the Obamacare problem was that you can't just completely separate employment and benefits because it's so intertwined at this point. And so, Obamacare was passed to kind of recognize that that's at this moment, an unentangleable relationship, and to try to improve it that way. But I think ultimately, if we want to get to a kinder, gentler place where it is easier for employers to provide these accommodations and not have an undue hardship, that is something that I think we'll have to think about. But in terms of where protections could go next, it is very, very hard to get anything passed at the federal level, as we already said. But I think states are already passing paid leave, and that will have to continue. That's huge. It's ridiculous that we don't already have it at the federal level. It would be much easier for employers like mine to manage a federal paid leave scheme instead of all these different ones. But, that is where the next focus has to be. They were so close with the Build Back Better Act, and that ultimately got pulled out. And it's something that's hard for me as a woman and mother to understand why, but I think eventually we will get there. But states, it'll be similar to this. I would guess a bunch of states are going to have to do it first. And frankly, our birth rate is falling. Our maternal fetal death rate is pretty high in this country for an industrialized nation. The birth rates are falling because of these kinds of issues and all the other issues, scarcity of daycare and difficulty of providing health and stuff. And eventually we're going to get to the point where the country's going to have to start investing in making it a more attractive to give birth to children. And maybe that will turn the tide too. But those are my thoughts.
Thank you so much. So now we will open it up for questions from the audience. Questions? Gallery back on, or you can put them in the chat if you're shy. Are there questions?